and you're gonna like him. He's a licensed California attorney for nearly 10 years, considerable experience in the area of estate planning through the proper use of trust, and was mentored and trained in large established law firms by some of the top estate planning attorneys in California. He has blogged on the topic of estate and trust since 2009 and has also been published in print media. VREN has provided customized in-house training in the areas of estate and trust planning to advisors and clients of organizations such as LPL Financial, Northwestern Mutual, Central Valley Community Bank, and associations of tax advisors. He has also served on the board of directors for Fresno County Young Lawyers Association and has been associated with the Trust and Estate section of the Fresno County Bar Association, as well as with Wealth Council, a national organization of state attorneys. VREN graduated in 2004 with distinction on an academic award scholarship from the University of the Pacific, McGeorge School of Law in Sacramento, California, where he has since returned as a guest presenter and trainer. Basically, he is more than qualified to speak to us today. Thank you so much for being here, and please help me welcome VREN Paul.
How's that? That's better? How's everybody doing this morning? Woo! Thank you for that introduction. That was great. I've never done an estate planning talk. It's going to run somewhere in the universe of about 12 minutes, so it should be super interesting. I'll start with this. I've been talking about this stuff for going on 10 years now, and I like to put it in context of what estate planning is and what it isn't. Let's talk about what it isn't. I think back to a conversation I had with a gentleman who works for Edward Jones. You've probably heard of that organization. He was telling me about his background in the military. He was in the Army for a long time prior to getting into financial services. And he told me the story about what they had everybody do. They had all the guys lined up as part of what they have to do relatively early on in that process. And they had them going through creating a will. And this is the extent of how that looked. So they had a sergeant walking through saying, okay, who do you want to get your stuff when you die? Scribble it down and go to the next person. Who do you want to get your stuff when you die? And scribble it down. Better than nothing, definitely, but it's not what estate planning is. It's a lot more than just that. So we'll talk about a little bit about what it is. We'll talk about some of the common techniques out there, and because we've got such a short period of time, I'd love just for a real quick minute to open it up to you guys. Is there anything in particular that you would like to learn, if it's possible for me to provide that information in the next 10 minutes or so? Is there anything? Thank you.
Living trust, like when you go in the hospital and they ask you, and I always say, oops.
Right.
Don't have it.
Yeah, living trust. Probably also talking about advanced healthcare directives with that. Okay, we'll talk about that. Let's just talk about that right now. Is that okay with everybody? All right, so tell me your name real quick. Dorothy. Okay, so what Dorothy's asking is, you've got a situation where you or somebody that you love is in a hospital. Okay, things are bad. If we can communicate, then that's not an issue because we can communicate, right? We can say, I want that medication, I don't want that medication, I want this treatment, I don't want that treatment. If we can't communicate, then we've got a situation on our hands. Because as you guys probably know, doctors are getting really good at keeping people alive for a pretty long time. Possibly artificially a lot longer than we might as individuals want, or that our loved ones might want. Some people get creeped out about the idea of staying alive for a year or more when nothing's happening. It's just a machine that's keeping you breathing, ventilator, or artificial hydration, nutrition. A lot of people do not get very comfortable about that situation. So in order to have instructions that are honored, if you cannot communicate those wishes on your own, you've got to have a document in place legally that will say two things. One, it would say, let's just say that I'm creating mine. I might say, I'm going to appoint Dorothy as my agent in fact to be able to make medical choices for me if I can't do it. And here's what I would want to have happen. And you can get really specific. And if you're sitting down with a qualified estate planning attorney, they're going to go through a series of different options and questions so you can decide in advance if you've got a certain situation. And it gets really specific. It can be things like if I've already got some kind of a life-threatening condition and I develop another life-threatening condition, Don't treat the other condition, just let me die naturally. We get real specific with that. So you've got to do it in advance. There's a lot of ways that you can go about doing it, but without that document, it can create a real challenge. And if you've ever heard of Terry Schiavo in the news years back, it can create some real issues. So thanks. Anything else? Okay. If there is something, please just throw a quick hand up and I'll try and cover it if I can. Yes?
How about when you're leaving money to your children and they're probably not mature enough, even though they're adults, to maybe incrementally disperse?
Yeah. So I've got a friend named Mark. His name actually is Mark, but I'm not going to protect his privacy, but a lot of people are named Mark. So Mark is 21 years old when I was living in Fresno in college. Mark gets $75,000 from his granddad. Not bad, right? He immediately goes out with his now ex-wife, buys a Cadillac Escalade SUV, just dials in their house with theater system and flat screen TVs mounted, all this great stuff. The money probably lasted all about 4 days. A year later, Mark's divorced. Everything's considered community property because they bought all these assets that are not registered in any way that's going to protect that property. So what we want to do when we're setting up, and this doesn't matter if it's a house, it doesn't matter if it's annuities, life insurance, any kind of an asset, if you're leaving it behind to somebody who's not old enough to manage it, and just because somebody's 18 doesn't mean that they're old enough to be able to be responsible. So you've got to have instructions either through a will that creates a trust, and we'll talk about what that is in just a second, what a trust is, or you actually have your own trust that says, I'm going to leave behind everything I own, let's just say to my spouse if she survives me, and if she doesn't, then it's going to be to my children. We'll share it equally. But if they haven't yet reached the age of, let's say, 25 years old, then I'm going to give a third of what I have. They can have unfettered access to it at age 25. I'll give them another third at age 30, and another third maybe at age 35. And those aren't magical ages. But until that point, you'll have somebody that we trust. And lawyers are really clever. We call that person a trustee that's going to be appointed. It's somebody that you know, that you would, that if it weren't you, somebody in your life that would be responsible saying, okay, Johnny, you've got tuition coming up, you've been working a lot, but I realize that there's some expenses that you need that falls within what your mom wanted when she set this trust up with us. I'm going to go ahead and write that check. So the trustee's going to hold the purse strings. You get to decide as a client what are the instructions. It's what really estate planning is. How many of you have young children here in the room? Okay, we had a PowerPoint up here. I was going to show you a picture of my beautiful son, but I always like to tell a story about the first time that my former wife and I left him with a babysitter. And the series of instructions, I used to have a letter that I would read, and it's amazing how much information that a woman can fit on one page. It just blows my mind. But this is one page of information that's just so specific about here's when he's going to wake up, and here's what kind of mood he's going to be in, and here's the diapers that you use, and the powder, and here's what he's going to eat, and then he's going to want to watch this show, and it's so specific, and that's what estate planning is. It's designing a set of instructions if you're not there anymore to take care of the people in your life, whether that's because you became disabled or because you died, how do you want that stuff to be handled? It doesn't happen automatically, and it's not what most of us associate this process with. It's, we think, okay, I need a will, and we call up our attorney that we know that maybe handled a traffic ticket for us or a real estate closing or something like that, and we say, hey, Charlie, do you do wills? And what does Charlie think? He's like, okay, well, I've got some forms that I have access to, and I can make some money here. So yeah, come on in. I can do a will for you. And then Charlie's going to sit down. He's going to go through a series of questions. Are you married? How many kids do you have? How much money do you have? And all this stuff. And then he's going to pull out a form book and try and plug you in that. And those types of situations fall short way too often. If you're sitting down with a qualified estate planning attorney, you're going to spend considerable time doing 4 things. One is going to be education. We're starting that process right now, so you guys have somewhat of an idea of what the different tools are with as much time as we have. Then you get into actual design. Okay, once a client has educated the lawyer about their situation, the lawyer is going to educate that client on how to design that plan with the proper documents to make sure that it works. Then we've got implementation, and then funding of any assets, something I see a lot out there. We'll talk about trusts for just a second. I'll make it really easy for you guys to know what a trust is. How many of you have heard of a living trust before? Really common estate planning tool out there. And a lot of people have trusts, and a lot of my clients, the way I started my business is I say, bring in your current estate planning documents, bring in your living trust, and take a look at all the assets that you have, and I won't charge you a dime for it. And out of 2 or 3 years, there was only one time that someone didn't wind up working with me, because all the time I would look at the assets that they owned, and I would look at this wonderful, beautiful trust document that they had created, and nothing was integrated. Nothing, the proper asset titling hadn't been done, or bank accounts hadn't been registered, beneficiary designations haven't been updated. Think about this for a second. Let's imagine that you've got a really well-drafted estate plan. You've got a living trust, you've got a will, you've got all this stuff. A lot of you are realtors in here, right? Yep. Let's say you sell a house to a married couple. How do they usually take title to that house? Joint tenancy, right? Joint tenancy is an estate planning technique. What happens with joint tenancy if one of the joint tenants dies? Do you know? The other one gets it automatically. There's no probate, there's nothing that has to happen. But what can happen though is people get blindsided by that, and they have these beautiful estate planning documents, and then most of their assets bypass them altogether, because jointly owned real estate, it doesn't matter. You can have a will or a trust that says I leave my house to my children from a previous marriage so they can use it as a vacation home, and if it's held in joint tenancy with a new spouse or with somebody else, it doesn't even get to that will, doesn't even get to that trust. Jointly owned property completely trumps the most beautiful estate planning that might be drafted. Does that make sense? I'm seeing some nodding heads. So the lesson there is that the way you own title is a really popular estate planning technique, and it's a really important one to make sure that it's integrated properly with any documents that might be there. Yes, sir.
So if somebody wants to make an appointment with you, what can they expect? How should they prepare, and what can they expect in terms of timeline and things like that for an initial appointment? Yeah,
for sure. I put a couple of different options. Let me see. Kind of borrow, you got one of those, Vicki? Not the pen, but the pretty sheet. There's a couple of options right here. One is, how many of you have estate planning documents currently? You got a will, you got a trust, you got something like that? Okay. Regularly, I do a $400 session to go through everything. That means I'm reviewing it, I'm talking to you, I'm getting to know you, I'm going to inventory what you've got, make sure everything works. I ordinarily charge $400 for that. What I'm going to do for any of you in this room, and I consider charging a minimal fee for it, I don't really think that's going to even be necessary here. So if you've got documents currently, just flip this over on the back, fill out the basic information, check peace of mind review, and I'm not going to charge you anything for it, so it'll be $0. I'll do that complimentary. Usually take a couple of hours. Yes, sir.
I have a couple of questions. One, if you already have one, but you want to change it, would you look at that also?
Yes, and I'll let you know if I think it ought to be changed, and sometimes it doesn't.
I'm going to put my kids on a wild goose chase and leave them $1 each.
You're all witnesses to that.
And also, I have a lady that I have trust of. Now, when she does go, she doesn't she's going to give money to a cat, all these cat organizations, but she doesn't have it all put out. Does that mean that I have to make all these choices?
They have a lot of discretion probably to how to do that.
Valley Humane Society. She does already, I know.
Yeah, they probably have a lot of discretion to choose, but she can choose.
And then, well, she
writes it
really
down.
hasn't, she's 90 years old. And then, when she does expire, does that mean I can sell her house because I'm her friend and realtor?
That might be a conflict of interest if you're going to be executor trustee. I'm almost certain that it would be. So you might want to rethink that. You might want to have somebody else, and you can say, "Hey, Janie, I will help out. Just don't put me on the document so I can sell your house." Practically speaking, you can do a lot of things. You just won't be signing documents or filing papers.
But if she says that that's what she wants,
Yeah.
then I can't really, because she designates.
You're going to have a potential conflict of interest. Let's chat a little bit more about it after the meeting and get specific. I want to make sure I answer the second part of that question. A lot of you, this is, if you want to come and meet with me, great, we'll do it. I won't charge you for it. I'll make sure that you get the right information. For other people, I just had a chat with somebody after a meeting just like this. He said, yeah, I've been meaning to do this. I have a 13-year-old daughter. I've been meaning to do this and sit down with one of you guys ever since she was born. That was 13 years ago. I hope it's not another 13 years before I finally get around to doing that. I hope, okay? So there's a second option. I'm going to borrow your form one more time, Vicki, and then I know we got to get done here in a couple seconds. For those of you who just want to get something in place and you want to make it uber convenient, you probably heard you have a lot of options. You can do things like LegalZoom, where you go online and they've got all these disclaimers that you're not getting legal advice, but you can create documents. I've got a similar system set up, so I try and use technology to help people on a wide scale just to get started. So the second option, where it says Essentials Package, the way that works is if you fill out the back here, and this is not free, but I'm going to make it super easy for you. What you do is you put down the very basic information, full name, password. Password is for your online login that I'll give you. Spouse's name, it's all super clear. You fill this out, and what I'll do is I will email you a very detailed online interview where you'll go through all the same questions I would ask if you were sitting in my office. It gets a lot of the work done virtually. You can do it in your PJs on a Saturday. Do it this weekend, do it over the Christmas break, just do it sometime. Gets everything pretty much dialed in, and then you and I will sit down either on the phone, via web meeting, or face-to-face, because I'm here locally too, and I'll make sure that everything's been done right. I'll make sure you understand what you've done, talk about how it all works, so you've got that peace of mind. That ordinarily is $650 to do that. What I'll do for you guys, if you want to take advantage of it, you want to write this down where it says investments. If you want to do the online thing, get some, just the basics that you absolutely need to have set up. You can do that for $199. And if you've got a spouse, it's $99 additional. So you got a couple options. Either turn this in and say, I want to meet with you, and then fill out the information, or if you just want to get something in place and you know you're going to procrastinate, so you want to get something set up and make it easy and then have the relationship developed, so when it makes time to really get into it and maybe do a trust or something, we can talk about doing that. Yes, Brian?
Where's your address?
It's Livermore. It's not on there. Just call. I've got business cards, but if you turn that into me, then we'll actually reach out to you to set it up. But I've also got business cards here in my little folder.
And what if it's my mother-in-law?
Yeah, sure. Absolutely. Yeah, I wish it was here.
That's very reasonable also, because I spend a lot more money, and this guy said he was my friend.
Oh.
So, that is an excellent price for us, and, we really need to do it because nobody lives forever.
Awesome. Yes.
Brian, just to be clear, so the lower section still is not really a trust we're talking about here,
You
right?
won't get a trust for that. You'll get a will. You'll get the power of attorney for financial management, which you've got to have. I was just in Chase Bank the other day, and there was a man, poor guy, is just fighting with these people at Chase Bank. He's trying to get access to his mom's bank account. She's 90 years old in an old folks home. For 3 years, he'd been kind of doing things for her, and they just let him, and then they stopped because there was a management change. And he didn't have the right documents in place where he could go in and take care of them on. And the poor guy's just stomping his feet. He said, we got $300,000 in here. I've been here for 3 years. Could have been it's so easy to avoid that. So you get that document, and then you also get that healthcare directive that Dorothy has to come. Yes?
Does that service include the power of attorney?
Yeah. Yeah, so you get will, you'll get that document, power of attorney, and you'll also get a healthcare directive plus a HIPAA privacy waiver, which is really critical to have that, because a lot of times anytime you go to the doctor, they beat you over the head with your privacy rights. So what that can mean is you can have this pretty healthcare directive, and then your spouse or your agent or whoever walks in and says, hey, I'm here to be able to help out, and they're saying, I'm sorry, I can't give you access to their information. It's protected under HIPAA. So you get this catch-22. So we'll also put together a really simple waiver that integrates that so it actually works. Yes, ma'am.
Can you tell me a little bit about how much you charge for a trust?
For a trust, yeah, for a married couple, it's typically about $2,500, and that's going to be fully funded, fully functional, no hourly billing. It's like it's going to work. It's not. I don't do for $1,200. I'll create that, and you go and do everything, because those never work. So I go through every asset with you. For non-married, it's between 18 and 2 grand.
Is this for portable property in the trust?
Yeah, typically with just one house in this area, I'll wind up saving clients in excess of $30,000 in probate fees just by putting one house into a trust. That's just a house. So you might pay a couple grand, but you're saving mad dollars on the back end. I just did somebody last week. We put in property in San Francisco, Kansas, Arkansas, and Missouri. And I got people in Singapore now with that girl. So yeah, not a problem. Okay. Thanks. This has been fun. I hope this has been helpful. Just give me the forms if you want to highlight on the over here.
Thank you very much, yeah. Did you guys find value this morning? Great, great. I wish we would have been able to give you more time to just, sometimes you start this meeting and everything looks like, oh, we got plenty of time. Next thing you know, it's like, oh, holy moly. Well, we're gonna let you guys go. It's a Friday. Enjoy your weekend. We'll see you all next Friday, okay? Thanks for being here today. Oh, wait, I'm sorry.
Wait, maybe we have to spend